Welcome back to the New England Take. Excited to be joined today by Professor Daniel Pye of the University of New Hampshire Franklin Pierce School of Law. Welcome to the show.
Thanks for having me.
All right, so I'm kind of sick of seeing this analogy, but it's very accurate in my opinion. Where the boss from The Office goes up and declares bankruptcy.
I declare bankruptcy!
That's totally what it seems like the presidents are trying to do with our constitution right now, and I had to talk about it with with a lawyer because I
Okay.
feel like I'm going crazy. So what we'll do is we got two different things, one with Biden and one with Trump,
Okay.
both kind of, in my opinion, probably going above and beyond what they should be doing, but we'll take it one step at a time. So to start off with, I want to start with President Biden. This was on active president at the time when he did this was January 17th, 2025, and he decided to tweet out, "Today I'm affirming that I have long believed in what three-fourths of states have ratified. The 28th Amendment is the law of the land, guaranteeing all Americans equal rights and protections under law, regardless of their sex." So, we're going to make this part of the Constitution perspective, are we missing something?
Well, I mean, he can tweet whatever he wants. That doesn't make it part of the Constitution. I mean, there's nothing wrong with him saying that he affirms and he considers it part of the Constitution. Ultimately, it's not the president's call. It takes two-thirds of both houses of the legislature and ratification by three-fourths of the states. Nowhere in Article 5 does it mention anything about the president having to say, okay, so he doesn't even have to sign off on it. And so his saying that he considers it the law of the land, okay, great. Ultimately, who gets to say, I mean, there was, I think, there was some talk about trying to force the archivist to certify it as being an amendment, but that doesn't really do anything. I mean, ultimately, that would get, if anybody tried to actually use it, it would get challenged in the courts, and the courts would probably say that that's not part of the Constitution. And so, I think there was a little bit of a red herring there on the question of whether Biden can force the archivist to do that. I mean, in some sense, she's just the job is ministerial, so she has to if he insists. But she says she wouldn't, and so there's a whole thing about that. But ultimately, the question is it constitutional? And that question goes to the courts, not to former President Biden. And so that's a pretty easy one, I think. I mean, there are some respectable opinions. I mean, the ABA had an opinion. And also various other law professors have thought that the deadline is not effective. And so there's some arguments about that, but
Yeah,
I think
that's
you can
really
pick
that's
one
really
point.
interesting because that's an important part that a lot of I've seen, especially in conservative circles, brought up. That it was supposed to be ratified within 7 years, if I remember right, and
Yeah.
obviously we are decades beyond that 7 years. Like, is that something that they can really uphold? I've heard this argument for forever that, hey, we can just make this amendment live through other means, but we're past the 7 years when the states should have come together and with was it three-quarters of the states come together and make it live.
Yeah, I mean, the question hinges upon whether or not Congress can set a time limit, right? And they've done it many times. In some cases, they haven't done it. In some cases, they have done it, and nobody's really questioned whether they had the power to do it. So this creates a problem. I mean, the way the law works is that we need precedents, and so there's no precedent establishing whether or not Congress has the power to set time limits on ratification. In general, people have just kind of assumed that they do because they've done it and nobody's objected to it. And that's kind of how a lot of constitutional law, for better or worse, gets made, is just inaction. And after a while, we just assume, oh, well, that's how things are done. It's norms that calcify into legal rules. But I think there's a reasonable argument to say that, well, Congress never had the power in the first place. But where are you getting this? I mean, the text of the amendment doesn't really say anything about it. And I think that the weight of the sort of momentum and the inertia of history would probably tell in favor of saying that the time limit is valid. If it's not, though, then it raises another question, which is can a state pull out of it, right? I mean, it's true that after the time limit had lapsed, three additional. I mean, the reason why they're now claiming that 38 states, which makes three quarters, um, more than three quarters. The reason why they're claiming is that three states have since ratified it after the deadline, and so they're saying, oh well, we got to 38. But before the deadline had even lapsed, five states had decided that they wanted to pull out of it. They wanted to unratify it. And so, okay, if you want to say that there's no time limit, then what are you going to say that there's also the states can't rescind their ratification of it? I mean, it seems like you have to look at it just so that you can ratify it after the deadline. That's fine, but you can't rescind your ratification of it. Once you've done it, it's set in stone. And then maybe you can say that they got to 38. And okay, fine. I think there are textual arguments for that. There are legal arguments for that. But ultimately, like, why? You have to ask, like, why did the framers make it so hard to amend the Constitution? It's because we want the process to reflect an overwhelming consensus of the country about some very fundamental matters, whether it has to do with rights or the structure of government or whatever. Now, if you're just barely squeaking in there by using sort of like technicalities and like invalidating certain things and not others, is that really in the spirit of the Fifth Amendment? I mean, I should think that if the way you want this to work, if you're a proponent of the ERA, is that you want it to be this overwhelming thing that everybody just agrees this is what we want our country to be like. And if you're having to squeeze it, like squeeze the text to get that, that just isn't in the spirit of, I think, what a constitutional amendment should be.
And politically, you're opening it up too for like you want some historians going in and pulling up constitutional amendments from dating back to the early 1800s and trying to just throw back in the face. Talk about making the Constitution no longer be seen as a valid document by people on either side of the aisle. You want to be very careful when you open these legal pathways with it's like, is this what we want to do? We doing this now? It's like I think both sides of the aisle, especially regarding this, are saying like we need to make sure we're keeping the ship in the right direction, because the Constitution is like the one document that this country kind of still says this is the structure we're taking. This is the formation of our government. These are the big understandings we're supposed to have. Yeah, we're still going to have fights over what exactly does the Second Amendment cover. Oh, First Amendment, like, does it really cover this part of it? There'll be specific things that are discussed, but overall, as a document and how it gets put together is so important, in my opinion.
Well, yeah, I mean, it is the most basic part of our law. It's the thing that sets up. It's the meta law. It sets up the structure for which all other laws are created. I'm not really sure if there are a lot of unratified amendments that are floating around that could. I don't know how much of a threat that is. I mean, the most recent time that the Constitution was amended was actually one of those leftover processes where Congress had passed it by two-thirds in both houses, and they were short some ratification, and there was no time limit on that one. It's kind of a small amendment. It's not a big deal, but it's about whether Congress people can vote for their own to give themselves raises, basically. And this was proposed in the early 19th century, and it just kind of sat latent for a very long time. And in the late 20th century, somebody just kind of noticed, well, nobody actually said that this process was dead. Unlike other attempts to amend the Constitution, there was no time limit that was specified, and so they tried to wrangle a few more states. They ratified it, and an amendment that had been drafted like almost 200 years ago was finally in the Constitution. So, I mean, that can happen. I think for anything that's politically fraught, it's unlikely that that process would be a big threat, though. I don't know. I mean, it seems to me that it's not implausible that something like the ERA could be enacted within our lifetimes. I mean, it's not. By the text of it, you might even think that the 14th Amendment already encompasses it, but the court has interpreted it as not applying to gender, to sex, or it does apply, but in a very limited way. But yeah, I mean, I think that if public opinion shifts, it's entirely plausible that in 20 years or 30 years that something very similar, if not exactly the same as the ERA, goes through the process and we amend the Constitution. That's fine. But it seems like this is not the moment because procedurally you're having to bend the rules to try to get it in there. And anyway, okay, so Biden says that he thinks that it is. I mean, it's just wrong. Nothing more to it than that.
All right, let's go over to the current president, President Donald J. Trump. So he's signed a just ungodly amount of executive orders since going into office, including from a stage, which is very Donald Trump to do, signing many just back this. Oh, I like this one, and going next executive order, going in line, which is
Yeah.
just such the moment we're in. But this one specifically, I want to talk about protecting the meaning and value of American citizenship was the executive order, and it's focused on the 14th Amendment, and basically it's trying to make a change to birthright citizenship. So if basically the nuance that is trying to be put across here to my interpretation, not as a lawyer, is that just because someone is born in this country, it does not necessarily mean they are automatically made a citizen if they are not. Their parents are not one or both parents are not American citizens already. So it's the
Well, I
whole,
think what he wants is that they should be here legally. They don't have to be
right.
citizens, but
That-
they have to be here legally. So they could just be on a green card or something like that.
Yeah, very good point. Very good point. And a lot of it, I think, comes down to one word: jurisdiction. Such a very, very legal news sort of thing to have to break down for people, where one word in this very important document could have a lot of impact, or in the very least keep the court system very busy for the next several months, or until whenever SCOTUS says, fine, we'll take it, and we're going to get this done, and we're going to move on with our life. So what's your take on this?
Right. So it says, so the 14th Amendment says that all persons born in the United States or subject to the jurisdiction thereof are citizens of the United States. So um, the qualification or subject to the jurisdiction thereof is, I think, the kind of textual hook that Trump and his advocates are trying to hang this on. I mean, so it's very unlikely that that's going to amount to anything. Um, I mean, there is a doctrine of constitutional interpretation called the rule against surplusages, which I teach in my classes. And it's a rule. It's kind of a meta rule that the court uses to interpret the Constitution. That is, when you interpret constitutional text, you assume that it has a meaning, that they didn't just put in words that don't have a meaning. So if they include the words subject to this jurisdiction thereof, then that must be some kind of a limitation on who's a citizen. It's not just anybody who's born. And historically, the people that they think that that might apply to are like the children of foreign diplomats, like the children of ambassadors who happen to be born in the United States. And then the reason why that excludes them, they're not citizens, is because foreign dignitaries are not subject to the laws of the United States, right? I mean, famously, if an ambassador parks illegally, they don't have to pay the parking fine because they're immune. It's diplomatic immunity, right? So if the diplomatic immunity means you're not subject to the laws of that jurisdiction. So since they're not subject to the laws of that jurisdiction, their children aren't automatically citizens if they're born here. Or an invading army. I mean, it doesn't really happen, but if an invading army
Knock on
were
wood.
here and occupying the physical territory of the United States, and one of the soldiers had a child that was born technically on the territory of the United States, well, the foreign invading army is not subject to the jurisdiction, to the laws of the United States, and so you would think that they're not included. But there's a famous case from the late 19th century, Wong Kim Ark, which the holding is that basically the 14th Amendment applies to anybody who was born here, and with those very narrow exceptions, birthright citizenship is a very broadly construed concept. So it's unlikely that trying to parse that language really finally is going to get Trump the result that he wants. It's I think in terms of litigation, if you're trying to get what is the probability of success, it's very, very low. I don't think that there is no argument. They would essentially be recycling the arguments that were made more than 100 years ago in Wong Kim Ark, which no one has really questioned since then. I mean, this Supreme Court, has shown a willingness to reinvestigate well-settled doctrines and to overturn them. So, maybe they will reject that rule and come up with a new one. I think it's pretty unlikely, though.
They've
you know,
also
this,
shown to be very pedantic, which has pissed off a lot of base conservatives in the MAGA movement too, especially Amy Coney Barrett, going like, "Yeah, this is not the intent of when it was written, and it doesn't always play out in Trump's favor with someone like her and some of the other conservatives. If one or two of the others side with the liberals, it's gonna just this is gonna be dead in the water."
Yeah, but I don't think this even comes down to partisan lines. I mean, I think a lot of times the characterization of the court is in political terms, and lately that might be a little bit more appropriate than it was, or more true than it was in previous generations. But I still think that the justices tend to be more persuaded by their judicial philosophies rather than partisan politics. So, the supposedly conservative justices, I think that they're more committed to textualism and originalism than they are to conservative politics. So if originalism and the original meaning of the text requires a result that is, in today's, spectrum of political ideologies, more progressive or liberal, I think that they would go that way because they're more loyal to originalism than they are to like the Republican Party or conservatism. But yeah, I mean, it's a little early, I think, still to say what Amy Coney Barrett's jurisprudence is going to look like. It's hard to predict these things, but I don't think it would necessarily go along partisan lines. For a lot of reasons, I would think that the so-called conservative justices would have a lot of good reasons to uphold birthright citizenship. The originalist argument, I think, tends to favor that. And also, they really like to emphasize stare decisis, the principle that you uphold precedents that are deeply, ingrained in the law. And at this point, it's more than 100 years. It's like 120 some years. So like, I think that they would not go for it. It's not a political thing. It's just their judicial philosophy is really committed to not making moves like this. So I think that's kind of unlikely. I also don't think that this is going to be a big surprise for Trump or the people in his camp. I am very skeptical that he signed this executive order thinking that it would actually work. I think that a lot of what he's doing is trying to take up, bandwidth. He's signed a lot of executive orders and some of which are pretty controversial and that are making big moves, which may actually be constitutionally within his powers. And he's, by like everybody's talking about birthright citizenship, which is basically not a winner. Which means that there's not really that much attention being paid to some of the other executive orders that he's issued. And I don't know. I mean, maybe that's deliberate. There's always this question with Trump is is he playing 3D chess? Is there something going on here, or is he just incompetent? I mean, and it's hard to suss that out. I mean, it's possible that this is deliberate, and he has people around him who are saying like, let's just blanket it, like just do all this stuff. Half of it is blatantly unconstitutional and it'll never get past the courts, but we never wanted it to anyway. We just wanted people to be paying attention to that while we did this other stuff. So maybe that's the strategy. I don't know.
It's kind of like congressional staffers. Like he has so many executive orders. Donald Trump. Let's remember the person we're talking about. He is not going in and writing these executive orders. I guarantee I doubt he's really read half of these executive orders. Like, oh, that sounds like a good idea. Big Sharpie toddler handwrite signature. I'm saying this as someone who voted for Donald Trump. Just anyone that's new to the channel and seeing me for the first time. Like, I voted for Trump. Like, I'm a conservative. But he's going in there writing his name onto all these things, and he's got a lot of strong staff that have a lot of opinions, a big team, especially when it comes to policy, that some of it he's literally fought with these people on. And he's going to sign it, he's going to go with it because now his name's on it, and it'll be really fascinating to see in 6 months things like this, like, oh, well, I did it because politically, like you're saying, I think that's a very good observation. It's like, hey, this was something that mattered to a lot of my supporters, and I wanted to get it out there and let's see what happens. Throw spaghetti at the wall version of politics. So it is that 4D chess versus like he's just going with the flow. Sometimes it's hard to figure out when he's honestly in the middle on some of this stuff.
Yeah, I mean it is basic. When he was signing it, I did catch a little bit of the video of that. He did seem surprised, or he hadn't read it. Like he didn't. what's this one? Okay, and then he signs it. And I mean, I'm sure that they had some kind of conversation about it, but there's almost no way that he was involved in the drafting and the lawyers were involved in all that stuff. But yeah, we'll I guess we'll see.
Definitely, there's a lot of that. All right, Professor Daniel Pye of UNH Franklin Pierce School of Law. Thanks so much for joining me.
Yeah, sure. Thanks for having me.
Yeah, law.unh.edu if anyone wants to learn more about the work they're doing over there. Great law school here in Concord, New Hampshire. All right, newenglandtake.com. Please be sure to follow on X and YouTube. Podcast is up and running. Lots of new things coming soon. We'll talk to you soon.